The following is an example of how a trial goes in The Hague and the International Criminal Court, or the ICC, and how some actions that are made by the organizations built for justice can be questionable. In 2003, the UN Special Court for Sierra Leone, or the SCSL, indicted the then president of Liberia, Charles Taylor, for 17 counts of alleged war crimes for supporting rebels in Nigeria who caused many atrocities. However, the president escaped into exile in Nigeria around the time that an arrest warrant was placed on him. In April 3, 2006, Charles Taylor stood in front of the SCSL and pleaded not guilty. On June 4, 2007, a year later, the trial began with the prosecution's opening statement. However, Taylor refused to show up since the ICC had not given his defense attorneys enough time to prepare. Now, why would they do that? On January 7, 2008, the prosecution began calling witnesses, and this process went on until February 27, 2009, and during this time, Taylor's lawyers first appeared in court. On April 7, 2009, Taylor's lawyers made a submission of no case to answer or motion for judgment of acquittal. This means that the prosecution had failed to prove Taylor's guilt. On May 4, 2009, however, the trial chamber rejected these claims that the defense had made. Getting a little bit angry over a little comment that usual defense attorneys make. On July 13, 2009, the defense opened with a statement from Taylor's lawyer, Courtenay Griffiths. He said that his client is not guilty of the charges against him. He then asked the question, why is Gaddafi, the leader of Libya, not on trial? Griffiths is quoted for saying, the court would have been refused funding by the British government had they attempted to indict Gaddafi because the British government and a man by the name of Tony Blair were anxious to pursue their economic interests in the country of Liberia. Griffiths then says that this whole entire trial was a politically motivated conspiracy by Western nations. He is also quoted for saying that it is to the shame of this prosecution that it is besmirched by the lofty ideas of international criminal law by turning this case into a 21st century form of neo-colonialism. On July 13, 2009, Charles Taylor took to the stand. After many days of testimony, he denied having any knowledge of the rebels in Sierra Leone. He then accused The Hague of making connections to him and the RUF rebels. During this time, the release of the diplomatic cables were released by WikiLeaks, which showed that the trial was not only unprofessional, but was meant to be so. On August 5, 2010, supermodel Naomi Campbell testified as the prosecution's 92nd witness. The defense claimed that this was another attack on Charles Taylor. By getting a celebrity to testify against Taylor, the trial will be more powerful and popular, and the prosecution will gain more supporters against him. On March 11, 2011, judges closed the trial after 3.5 years. On September 2011, judges are expected to come out with their decision on the case, but should they be allowed to? It is obvious that this trial has had its ups and downs and makes one wonder what The Hague and the ICC are really up to. Whether Taylor is guilty or not, the ICC has been found to manipulate circumstances to get better and more favorable outcomes, and they are fixing trials in order to get the outcome that will best benefit themselves. And if they are really doing this, is that really justice?